Welcome to one of the most exciting anticipated sessions of CMMC Con, a session with CEO Brian Markus of Aries Security, a company specializing in cybersecurity awareness, events, training, and education, and with his colleague and his lawyer, Greg Thyberg of Thyberg Law, who will both be joining us today as we talk about the whole notion of the False Claims Act and Defense Industrial Base cybersecurity. Welcome to both of you guys. Thank you for coming here today.
Thank you.
Thank you for having us.
Thanks, Brian. Thanks, Greg. I'd like to give a little introduction to both of you guys. Greg has been really been pushing, along with the U.S. District Attorney, a lot of initiatives on cybersecurity. We'll be getting into those, and we look forward to Greg's comments. And Brian Markus, although well known for his role in a suit against Rocketdyne, is a fellow that has a long, unbelievably great storied history on contributing to the cybersecurity space, including at the moment as he's the CEO of a very successful cybersecurity company, Aries Security. He's been the former CISO for Aerojet Rocketdyne, and where he held both technical and leadership roles at Raytheon, where he worked there for nearly a decade, as well as he was working for Riverside County Office of Education. He's been participating on many different national levels, including Obama's Telecommunication Council, and he's an ex-adjunct professor at DeVry University. Brian holds a Bachelor of Science in CIS and also an MBA. He has a million certifications on his name, from everything from very, very programmatic to very, very technical. And you probably know him most, if you're in the cybersecurity world, for his contributions to the world's largest gathering of hackers called DEF CON in Las Vegas every single year. And he's provided for lots of different content, even on NCIS, including Capture the Packet Cyber Range and juice jacking. So welcome to both of you guys. I hope I gave you justice, Brian, and your contributions, and I thank you for your time.
Thank you.
Yeah, so what we'd like to get into, I think this is the kind of the gist of the conversation and how we became acquainted, Brian and Greg, was this whole notion of the activities revolving around the False Claims Act and the Defense Industrial Base, cybersecurity. So what I'm really interested is having our audience here at CMMC Con understand, how has your experience in the defense industry informed your approach to meeting cybersecurity and compliance? I'd love to understand how you specifically, in being a CISO in the DIB, as well as owning a company that provides security services to the DoD, how has that experience informed your approach to meeting cybersecurity?
It's definitely heightened my awareness to the threats, especially in the defense industrial base. We see attacks against the DIB on a daily basis nowadays. But in the end, it's really about protecting the government data versus a checklist. So compliance is one step in the overall solution, but it's not the only thing that's there. And I use the knowledge that I have from doing both offensive and defensive missions, and the knowledge that I have for many, many years working with the US government on compliance and defense, in combination with the compliance guidance to provide resolution in any gaps that a company may have. So a lot of the time, a company that is fresh and new working on these compliance components, they see a ton of different gaps and they don't know where to start. Which one do we go at first? Well, it really does make a difference, and that approach should be based on where the risk is and where the threat is. So the thing that is the most vulnerable, the thing that will get the threat actors to that critical data first, is where you should focus on first.
Got it. You know, there's a lot going on. I know you're fully aware, and I know the audience is fully aware that the government's pushing the defense industrial base on cybersecurity and many new regulations. And the stalwart regulation points to the NIST 800-171. What advice would you give an organization who is just either beginning working towards the NIST 800-170 or is in the struggles or the throes of working towards NIST 800-171 compliance? How would you have them approach it, and what's your thoughts?
So I think that it's very important for organizations to take a holistic approach to this. Many companies will look at just one site or one section of an organization. They're like, well, that's the only part of the company that is doing any of that work. But the way that the regulations are, you need to put an envelope around all of the different things that are components to that regulation. And in many cases, it's the entire organization. So being compliant at one site out of 100 sites or 1 out of 2 sites does not make your organization compliant. So make sure that you look at your whole organization when you're applying the compliance components and make sure that you truly are compliant. And if you don't feel like you can go up and have a very simple conversation with somebody and say, yes, we are compliant across the whole organization, then don't consider yourself compliant.
Wonderful, Brian. We at CyberSheath, I know you realize we do a large business with the defense industrial base. That's what we focus on. And we hear time and time again from small and even large organizations that they hear things from the government and that they hear the government moving in a certain direction, but they don't seem to understand that or believe that the regulation will be either enforced or reinforced, or it doesn't really apply to them because of one special consideration. They're small business. They don't actually represent a risk in their mind to the government. Maybe I would love for you to opine. Now, what would you say to a defense contractor who don't believe in the regulation or the regulations or the scale or the scope or the enforcement and so forth? How would you respond to that, Brian?
That's a pretty tricky one, but the reality is that nation-state cyber attacks are in the news nearly every day now. The United States president recently issued an executive order to help the entire nation with cybersecurity and protecting our industrial base across the board. It's in the top of the minds of the public, politicians, executives, and boards. And whether this will or won't be enforced is really moot. It's everyone's role as a clear defense contractor to protect the information that the government's entrusting you with. Mm-hmm. And if you're a small, it actually in some cases is more important and more critical because the smalls tend to have less security and the threat actors have been picking them off one by one. The nation state attackers are able to see what the government is ordering, how many, when they're ordering them, so they can get an understanding of what we're actually doing as a nation and how we're doing it. And then additionally, for those smalls that are perhaps hoping to be acquired by a large organization later, this is actually a strategy of nation states. They intentionally compromise and get a foothold into small defense contractors. And then when a large organization such as the Lockheeds, Boeings, Raytheons, et cetera, of the world purchase one of those smalls, they have a foothold and compromise in that organization. They're hoping to bounce into the large and pivot around that organization. So there's really a critical need for the organizations to have this level of cybersecurity in place.
Yeah, right. Exactly. Greg, I'd love to get you to opine on this also, especially from the idea that a company is taking a contract and then is balking at the about the requirements in there. What's your thoughts on that, Greg?
Well, you talk about the government enforcing, and I think what maybe you have to understand on this is that the way our case got started was Brian came to me because he stood up to do the right thing, looked at what happened and looked at these regulations because I had done things in healthcare and other sorts of false claims cases. And I saw a false claims case here. Actually, our case is the first case of its type this type of cybersecurity, these regulations as a false claim. And actually, after our case, of course, was under seal for a number of years, but then after we won our motion to dismiss, it got publicized, and almost every major law firm that does government contracting has written something on this. And it turns out for years, the defense industry, the lawyers who represent defense contractors, knew there was this potential false claims liability. So it's not just about the government coming after your company. Every company has individuals in their company who, if the company is not complying, and I believe most of these people, if not all of them that do cybersecurity, are ultimately patriots that want to do the right thing. They can well come forward as a relator, like Mr. Markus did. In our case, the government decided not to intervene in the case. So we've had to carry this case and prosecute it on my own, on our own, without really the government behind us. But so the case went forward. Usually what happens in a false claims case is the government will intervene and settle the case. In our case, the government was concerned about what happened, but it took a while for us to really get through the discovery in the case and kind of show the government what was actually going on, because it was very complicated, thousands of documents to go through, and to really, of course, get the government's attention. Of course, also the time frame we're in is, this case was filed in 2015. Now we've had a couple presidential elections, issues of cybersecurity. It's in the news more. And as Brian pointed out, the Biden administration and what the government has done since this case has been filed, it's really on the front burner. But you, as a small company or whatever size company, for you to face false claims liability, these things turn up because people in your own company end up coming forward if they get frustrated that you're not complying with the law, or they see the threat. And that's where the effort goes forward. So it's just not about the government catching you. It could be people in your own company if you're not compliant.
I totally see that, Greg. Can you opine a little bit about how it works on the fines? How that's done? The law, what is the total liability a company would have if they were found to be fraudulent? Okay,
well, in the False Claims Act, these come up in all sorts of contexts, like in pharmaceuticals and in different sorts of industries. There's fines, like you could get $11,500, $22,000 per invoice that you submit, those sort of damages. But in this case, where we're dealing with these large defense contracts and the technology, and what we've done in our case, where we talk about fraud and the inducement. Fraud and the inducement means that you promise something to someone to get them to enter the contract, and you either say something that's false or you mislead them in some way. And if the court finds that it was a material misrepresentation such that, the government might not enter that contract, then the damages are, the case law is once you use fraud to get that contract or that government benefit, fraud attaches to every invoice that you submit to the government on that contract. So like in our case, we have a contract. One of the contracts is a several $billion contract that we've alleged was, fraud in the inducement. And so the argument we have is that every invoice that was paid on that contract is fraudulent. And that's what the case law is. So the damages, that's where it really gets large. The damages is kind of like a train leaving the station. Once you get that contract, those damages, every invoice, and it's not just what your profit is, it's like what your gross, what you got paid by the government. And then, of course, with the jury tripling that really just can become devastating.
So help me with that. The jury has to triple that after...
The judge does that. I'm sorry. The jury, you argue to the jury, they got contract A, and here's, the government records. The government paid this company X $1 billion, and here's the representations. And this was, material false things. They said they shouldn't have gotten the contract. If the jury agrees, they say yes. And then they're told they would get a jury instruction that say the damages, that fraud attaches to every invoice. So they fill in the jury verdict, $1 billion. And then after that, the act itself requires that it be tripled. And the reason is because oftentimes in these cases, the damages is hard to assess for the government, particularly in the defense industry. If some companies handling a contractor, they're like they have a prime contractor and they're sharing technical data with the subcontractor. They're handling intellectual property worth billions. Some of these programs are hundreds of billions of dollars that our government has spent to develop that program. And if they're using that information to build some part of the rocket or build some part of the weapon system, and a foreign country gets a hold of that, the damages are that we've given away intellectual property, billions of dollars that the taxpayers have paid for, and it's very hard to calculate the damage. And of course, the other part of it is if some rogue country or whatever to use that technology against us, or our men and women in battle face, are put at a disadvantage because some country now knows how to neutralize our weapons. It's devastating, particularly with the hypersonic technologies that are coming out. I mean, those things, if you looked at those, are very scary, the hypersonic technology, because it's going to be the whole next Cold War, the countries that have that type of technology, because no one right now knows how to counteract it.
I appreciate very much everything that you said, Greg. I've been in this industry, and I learned a lot from you just in this conversation. Just so if I understood it clearly, what you said, and I understand the law is that you can be fined up to the size of the contract that you have been awarded times 3, that the judge has his hands tied, that will assign a multiple of 3 times that contract or whatever it was, the fraud element. So that's huge. I appreciate that very much.
Yeah. Whether it's a $5,000 contract or a $5 billion contract.
What a fascinating set of questions, Brian and Greg, and answers and your sage advice. I'm thinking about the False Claims Act and why defense contractors should have been concerned with the business risk. Brian, what advice would you give to maybe people that are sitting in a similar situation that you're sitting in, where they're security practitioners or people in the business, and they just feel like they're struggling with the compliance element and getting recognition for the compliance element? How would you walk through some of that situation that you've already been through?
Well, I can tell you from going through this for nearly 6 years now, it certainly hasn't been easy. It's been the complete opposite of that. It's been extremely stressful through the entire process. I did lose my job with the organization through trying to do the right thing, and have gone through a whole lot of different things with this. And the world within the last decade went through a dramatic change and an understanding of what whistleblowing is, potentially. And there's a very poor example of whistleblowing where it was done completely improperly. They didn't follow any of the processes, and all the material that they talked about was then made public, which caused more damage to the government as a whole. With my situation, I was put in a very awkward position, and I had to make a choice. But before I was even put in that position, I was at the time given clearances and trust by the US government. And so I had to do what was right for the government regardless, or they'd never trust me again. And so I went through the proper process within the whistleblowing component, in this case, a key TAM case, with Greg's assistance. And we approached this completely under seals with the US District Attorney. There was no public acknowledgement, no public information of this. We were all very quiet about this. It went through proper procedures. There were many organizations, government organizations brought into this. This was all completely sealed. And then was released to the public later. In the end, if you're put in a situation that is, really challenging or impossible, the only thing, in my opinion, that you can do is the right thing. And whether that loses your current job or whatever it is, if I had done that, I would never work in the defense space again. In this case, I still currently work in the defense space on a regular basis, and I'm a trusted individual within the defense space because of that. And so I would just say, if you put in that situation, you need to do the right thing.
They say courage are those people that don't stay silent when they know what the right thing is to do. So I really applaud you for your courage and your tenacity in doing what you believe is correct and right. Greg, maybe you can help us understand, if I'm a company and I'm struggling as a company, as an owner, actually being compliant. Maybe I signed up for a contract and I really didn't understand what I was signing up for, and maybe really simply can't actually do it. So, and maybe it's not true, maybe that's not real, but let's say in the mind of that company, they are struggling with profitability or solvency and so forth. What would your advice be to them?
Well, yeah, these things are a struggle for not only small, for large companies, for small companies. So it is a challenge. And I think the government understands the challenge. What we shouldn't assume is just because you're not compliant, it's not, foregone that you're going to be hit with a False Claims Act. The False Claims Act has to really do with the disclosures that you make to the government. Where you get into trouble is when you're not forthcoming and you misstate things and you don't disclose things. The best protection you can have is when you enter that contract and as you go through doing contracts to be forthright in what you're saying. And the government understands that smaller companies have issues and they try to, the idea is the government wants to work with these companies. Maybe you can't be totally compliant with some requirement, but the act talks about doing it through other equivalent measures. I think there's an attitude among the Department of Defense and the government where they want to come alongside and help a company if they're not compliant, rather than find out that they haven't been compliant. There's been huge damage that's occurred. One analogy I have is this: when you think about when you sell your house and you get that real estate disclosure, and does a roof leak, does the toilet work? You're checking off those boxes, and we all have that sense like, gee, I don't want to check that because the person might not buy your house. Well, that's exactly the thing you have to disclose when you're working with the government, because if you know in your mind it might affect the government or a decision, then it's material to that contract. And the way you protect yourself is to be able to go back and show when the government comes later to say, well, I told you about that. Here's the form. Here's where I checked. Here's what I told you. Then there's no False Claims Act. And just because you're not fully compliant or you're struggling in areas doesn't mean you're not going to get the contract. But if you're not going to get the contract, it's better to find out now rather than do 5 years of work on the contract and find you owe all the 3 times the money you got back to the government. So the real area for as far as avoiding False Claims Act liability is not only complying, but making sure your disclosures are forthright, candid, and honest. There may be an excuse for not being compliant, but there's really no excuse for somebody being just dishonest.
It's funny, Greg, as you're talking, it's you go back to what mom and dad told you to do, right? Just be honest and be truthful and be transparent. And that'll keep you safe or on the side of safety throughout it all. That's wonderful advice, sage advice.
And also the penalties under the False Claims Act. You mentioned a company, if they got into a contract and not compliant, coming forward and working with the government, the way the False Claims Act works, first of all, they might not come after you at all under the act, or where companies voluntarily disclose, even if they're caught and then are candid at that point, the penalties are less. But the real problems occur is when you just try to continue to hide everything.
Wonderful. Yeah, that makes perfect sense to me. So maybe I'll leave you both with this final question. If you could just give our constituency base of defense contractors, what would be your suggestion in them starting out in their compliance journey? Like, let's suppose for a second that they've struggled with their compliance journey and they've been trying to more check the box than really live in a compliant world. What final words would you have for them? Brian?
Well, I think that every organization needs to think with the end in mind. What is their goal? So if they want to work with the U.S. government and they're looking at this policy and these regulations, what level do they need to be compliant with? 1 through 5. Where do they actually need to be? And then from there, when you know what your goal is, then you need to really spend some time assessing where you are. And when you understand where those gaps are, then you can build a strategy to close those gaps and work through all of those components.
Yeah, right.
From that, it's really another business decision. Do you build or do you buy? So do you do it in-house? Do you have the staff that has the time to do all of the policy writing, the technical process, all of the components there? Or do you have a third-party company come in and help you that does nothing but this? Do you build your own templates? Do you use somebody else's templates? Do you build and budget for all the technical components? I mean, there are so many things that are required as part of this regulation that people overlook. It's really important to do this right. And so it really are those three pieces, in my opinion.
Love it. Thank you, Brian. Greg, any final thoughts on your side?
Yeah, I think the important thing to keep in mind is, with all these, certifications and audits and Brian, people are checking off boxes. It's important to keep in mind the overall reason for these regulations. The DFARS clause, the first thing it talks about before it gets to all the requirements is that a defense contractor has an obligation to provide adequate security, which means they have to look at the probability of loss if they don't comply and what are the consequences of that loss. So we know in defense with the sort of technology that we're dealing with, the consequences of losing that technology, could be devastating. A question that you need to ask yourself is not just checking the boxes, but look at your organization and think to yourself, if this were my bank or my credit card company, would I be comfortable with them having my personal information, my social security number, or whatever stored on this system? I mean, that should be a level where if you personally would not be comfortable with storing your personal information, that's a huge wake-up call that the government shouldn't be storing information there. So
nice
look at the practical goal rather than just checking the boxes. Is it adequate? Because you could check all the boxes, and if there's one thing that's vulnerable, that's a huge problem, checking 100 other boxes doesn't do any good.
It's a great advice, really super sage advice. So I thank you both for the wonderful introduction of this concept into the CMMC Con, for your rich contributions to the industry at so many different levels, and for helping us move forward. I certainly hope that people from the conference reach out to you individually and thank you for what you're doing and how you're doing it. Honestly, I think you guys are both great Americans for helping us all become better at doing this. Thank you very much for your contributions, guys.
Thank you for having us.
I know.
Thank you.